Thank you all for joining us today. If you haven't worked with us before, we are a legal resource center that provides legal technical assistance to members of the public health community who are working on policy issues related to chronic disease. So we divide our work between two teams, one working on commercial tobacco control and the other on healthy eating and active living policy. But everything that we do is grounded in health equity. So we strive to work with our partners to identify ways to ensure that all the policies that we work on have the best possible outcomes for all members of a community, and not only don't exacerbate health disparities, but work towards correcting. The work that we do takes the form of legal technical assistance, which includes webinars and trainings. We create hundreds of publications that you can find on our website, but most of what we do is individual legal technical assistance, where we answer individual questions from advocacy organizations, state and local health professionals, and public citizens. We answer the complicated legal questions that are always embedded in policy work. There are only two things we don't do. We don't go to court on anyone's behalf, although we do file amicus curiae or friend of the court briefs in important litigation, and then we don't lobby. We do work directly with lobbyists from advocacy organizations, but we don't engage with policymakers. So before we dig into today's webinar, I just wanted to let you know that this is just the first in a series of webinars that we're doing that's going to be focused on litigation. You can join us next Thursday and the following Thursday for more litigation updates. And then on the 1st of December, we'll give you an update on what the FDA has been up to. That's all we have scheduled at the moment, but you can expect some additional webinars focused on the latest litigation and federal regulatory updates from us early next year as well. I'm really excited about today's webinar, which is on a topic that I think is really interesting and I care a lot about. The format today is going to be sort of a hybrid of one of our standard webinars and also some sort of open conversation about the topic. I'm going to start us off by getting us to think about litigation as a tool rather than how you may be thinking about litigation, perhaps as just a way to resolve disputes or just something to keep lawyers busy and employed. We'll discuss litigation in the context of tobacco control, which may or may not be something you're familiar with, but there's a lot to discuss there. We'll focus on one specific type of litigation, affirmative public health litigation, and then we'll focus on litigation in the context of environmental regulation. Thankfully, I'm joined by my colleague, Kira Hill, who has a lot of experience in that world. And then before we turn to the informal portion of the webinar, we'll introduce you to a new tool that we've developed and will be growing and improving. I should say, if you have questions along the way, feel free to put those in the Q&A box, and we'll try to pick them up at the end when we're sort of discussing everything together. Now, to kick us off, this probably isn't really a surprise to anyone, but when I'm discussing litigation with public health folks who aren't lawyers, I'm reminded of something that lawyers probably pretty often forget, and that's that we think about litigation very differently than people who aren't lawyers. And I know that's kind of an obvious conclusion, and it almost goes without saying, but I really think there's a couple of things to unpack in that before we really start to dig in too deep. For most people, you encounter litigation in just a couple of ways. I mean, you see the fictionalized versions on TV and movies, or maybe you're into the true crime stories. And you know this, but the fiction is rarely realistic. And, the true crime stuff is generally like the most unusual cases that we run into. And they're not particularly generalizable. And criminal law is obviously very different than policy-focused litigation. You may also have been a participant in litigation, unfortunately. I mean, ideally, you go through your whole life without that happening. If you do get wrapped up in some sort of conflict, maybe a property dispute with a neighbor, you probably hire a lawyer and you end up participating in the process at an arm's length. For parties who are resolving conflicts, litigation can be emotional, draining, and the resolution can be less than ideal, and the whole process might leave you with a bad taste in your mouth, so to speak. Probably the other most common interaction with litigation is that you're following a particular policy issue that you really care about, and that's the subject of some litigation. Now, as probably can be expected, media coverage of litigation tends to focus on the dramatic developments and what seem like really important outcomes, even when the drama is actually something that's to be expected and the outcomes are temporary. Now, this isn't to bash the media, but if your incentive is to sell papers, get clicks, or improve ratings, you're going to try to make something small into something big. And small developments can be important, but they're not often discussed with the proper context. The classic example is a case where there's a lower court ruling, and everyone knows that that's going to be appealed. When it comes to policy litigation, lower court rulings are not the only part of the story. Think of it like the first couple of chapters of a book. It's important, sure, it's going to set the stage for what's to come, but you don't stop reading at that point, and you don't really dwell on that because there's lots of story left. The other thing to keep in mind is that when we focus just on the outcome, litigation can end up feeling arbitrary. Either the policy that you want to see changed is changed and the outcome is just obvious, or the policy isn't changed and then the litigation just feels unfair. So we need to shift our thinking a little bit to try to understand what litigation can do and what it can't do, the strengths and the weaknesses. So one way to maybe make sense of this is to go all the way back to your high school civics class. We all learned about the three branches of government. The legislature makes laws, the courts interpret the laws, the executive branch enforces the laws. Now, that's not false. That is true. But I can tell you that as a lawyer, we really think about all three of these branches as having the power to create laws, in that each of them can take different actions that are binding and enforceable. Each branch has different rules and procedures. They vary in their degree of openness and the ease of participation, but each branch has a role to play in changing policy. We'll dive a little deeper in a minute, but I think that for most of the history of tobacco control, we've had a very limited view of how the judicial branch can change policy. Before we turn to how litigation has been used and can use, a couple of caveats that we definitely have to mention. So litigation can be incredibly powerful, but it is exceptionally difficult to control the outcome, so it must be used with caution. Similarly, litigation can be a very blunt tool, and it's not always the best method of policy change. So it's best to think of it as sort of the last resort, the last tool in your toolbox. It certainly does not replace grassroots organizing, which the tobacco control community has long relied on and had great success with. Litigation can be disempowering for parties. It can feel like you're giving up your power to lawyers and judges who have their own language, archaic procedures, and they move very slowly. If you enter litigation with the same sorts of expectations that you have for organizing and lobbying at the local level, you're going to be very disappointed with how things go, win or lose. Litigation can also be really expensive and can take several years to play out. And in fact, you've probably seen this, but it's not terribly uncommon to see litigation resolved because a legislative body changes a policy that was the heart of the lawsuit. Litigation is also a process that can be drawn out even longer if that's the litigant's goal. And perhaps most importantly, litigation is risky. You can have great lawyers and a great case, and you can still lose. And when you lose, litigation can have adverse results that last for a long time. Now, the inverse is also true. Good outcomes can also stand. But litigation is often more risky than attempting policy change through one of the other branches. Now, I'd like to set the stage before we dive into a deeper discussion of what's happening with affirmative litigation by looking at litigation in the past. So in the modern era, the first lawsuits that were brought related to tobacco products were filed in the 1950s and 60s and the early 70s. And those were individuals suing the tobacco industry for the health consequences of smoking. Now, at that time, the industry was very effective at denying science and winning those lawsuits. In the 80s and 90s, the industry was able to deny the science of addiction and point to policies like warning labels to argue that people were making a voluntary choice that the industry couldn't be blamed for. They were also pretty successful in those suits. But after the disclosure of internal tobacco industry documents and some of the other lawsuits we'll talk about, plaintiffs were finally able to start winning lawsuits and receiving compensation from the industry. And that was happening in the 1990s. Now, there's still plenty of lawsuits currently being litigated about the effects of cigarettes, and we've also seen a huge wave of litigation related to e-cigarettes as well. Starting in the mid-1990s, there were several tobacco industry whistleblowers who leaked documents to the media and to government officials. And there are a variety of important things that happen as a result of the depth of the tobacco industry's deceptive practices being publicized. But the ones that are important for our purposes are there were state lawsuits against cigarette manufacturers that led to settlements between manufacturers and the states. One of those is the Master Settlement Agreement. The other is the federal government's racketeering lawsuit against those same cigarette manufacturers. I'm not going to go into a lot of detail about those two events because we actually have some really good resources on our website about those, and I would encourage you to check those out if you're interested. I mention them now because they are two of the most important examples of the government using litigation as a tool to combat the industry. We mostly probably think about government dealing with industry by passing laws and sometimes as regulators, but the government can act as a plaintiff as well in some circumstances. We're also well aware that when it comes to industry and government, it's a two-way street. And the government, whether it's state, local, or federal, is far more often on defense than it is on offense. The bulk of the litigation that we work on in commercial tobacco control fits into this category. And this isn't going to be the focus today, again, because we're going to be discussing that in depth next week and in the future. So check out our next webinar to talk about industry lawsuits against the government. But finally, the focus of this webinar is this era that's been missing. Public interest and individual lawsuits against the government. So this has been the missing piece of the puzzle in tobacco control for a while. And I don't think we should dwell on the potential missed opportunity of not having used this tool to its fullest. First, as we'll be discussing, the primary target for these lawsuits is the FDA, and the FDA has really only been in the business of regulating tobacco products for the last decade. Well, tobacco control dates back to the 1950s. But I think that there's another important reason for this as well. I think that for a lot of us, this might be how we've been conceptualizing this relationship. Government and public health are partners on the same side against industry. And that makes sense. I mean, it makes sense to me. We work with folks from state and local public health departments. I know some of them are watching today. We work with folks from CDC, and we're all working toward a common goal. And we've been doing that for a long time. And, absolutely the same can be said for the FDA as well, to a degree. I have friends and colleagues that work there, and I have the utmost respect for them, and I know they share our passion. However, we have to start thinking about the FDA in particular as a sort of third party and not always a partner. It's a complicated relationship. But I think that in the time and place where we live, we can start to grasp that complication more so than we could in the past. Sometimes government bodies do what we hope, and other times they do the opposite. I suspect it's a little easier to imagine ourselves as litigants now. So if we maintain that separation, we have another avenue to pursue policy change. We can't leave that tool behind if we want to achieve our goals. I will also say that I suspect there's a degree to which we've been envisioning litigation as a sort of dirty tactic. And I think that's definitely warranted as well. We've seen the tobacco industry use litigation in ways that are illegitimate. The term scorched earth is often used to describe its litigation strategy. I think that decades of seeing the industry drag out lawsuits and threatening and bullying small cities and counties, it's made it feel like litigation is an unjust means to an end. Hopefully we can put that notion behind us and focus on the opportunities that affirmative litigation against government can provide. We need to really internalize the fact that even if the industry uses litigation as a dirty tactic, we can use it legitimately, the way that our government structure was built to. The courts are supposed to be open to everyone. That's the way the system was designed. We shouldn't see ourselves as the bad guy when we're holding the government accountable. All right, so at this point, I'm going to turn things over to my colleague, Kira Hill. She's going to talk about some of the latest examples of affirmative litigation.
As Desmond mentioned, we have recently seen a bit of a sea change when it comes to the role that affirmative litigation has, that the role that public health groups have played in holding FDA accountable. So I'm going to talk about three different cases that I'm calling kind of game-changing cases. Two of them were actually led by the American Academy of Pediatrics. One has to do with graphic warning labels, and the other one has to do with pre-market review. And then, as I'm sure a lot of you have heard, the most recent case was a case brought by AATCLC and ASH that has to do with FDA's lack of action on menthol. So I'm going to talk about each of those cases. Okay, so the first case has to do with FDA's mandate to issue graphic warning labels. The Tobacco Control Act requires FDA to issue graphic warning labels, and it actually imposed a 24-month deadline by which it had to issue graphic warning rules. So FDA issued the rule in 2011, and as Desmond mentioned, the industry is extremely litigious. It sued FDA, and then the rule was overturned on First Amendment grounds. If you tune into our webinar in a couple of weeks, we'll go into more depth about the graphic warning label cases and the ones that are going on right now. But right now, just keep in mind that the rule was overturned. And then as of 2016, FDA had not issued a new rule. So AAP and other public health groups sued FDA. And essentially, what the outcome of that case was that the court agreed with the public health groups. It said, yeah, FDA has unreasonably delayed the action that's required under the act here, and it required FDA to issue a rule. Interestingly, FDA appealed that decision, but it still complied with the deadline, and it issued a rule in March of 2020. So this past March, and as I mentioned, the industry is really litigious, and so the industry has sued. 2 different lawsuits are now going on, and we'll talk more about that in the webinar in a couple of weeks. And just to the right, you can see just one of the labels that FDA required to be put on cigarette packages and advertisements in the new rule. So that was kind of the first major situation in which public health took it upon themselves to push FDA to do something that it was required to do under the act. So next is another AAP case. This one was in the District of Maryland. Both of these were federal court cases. And this one has to do with pre-market review. I'm sure some of you are familiar with pre-market review and the fact that the Tobacco Control Act requires what it defines as new tobacco products, which are products that were marketed after February of 2007, to receive affirmative marketing orders before they're sold. That's what the text of the act says. And since most e-cigarettes are new tobacco products, technically, those products should not be commercially marketed until they receive an affirmative marketing order from FDA. Obviously, that's not happening. And part of the reason is in 2017, FDA issued guidance extending the timeline for companies to submit applications, and then it essentially indefinitely extended the time for which products could remain on the market. This is not at all what the text of the law envisions. So again, AAP and other public health groups sued FDA to require them to go through with this essential review process. And as many of you probably know, they won. And in last year, the district court imposed a new schedule, which originally had a May 12th, 2020 deadline for companies to submit marketing applications. Because of COVID, that was extended to this past September 9th. So on September 9th, all the manufacturers that wanted to submit pre-marketing applications should have submitted those applications. There's a lot to be said about how that's being enforced right now. The judge still has jurisdiction over the case because there are ongoing deadlines, and by 2021, September of 2021, the only products that should be on the market are those that receive an affirmative marketing order, and we'll have to see how that goes. But the point here is really that in both of these AAP cases, public health groups saw that FDA was not doing what it was required to do by the act, and they realized, we have this tool. We have a tool to force FDA to do what it needs to do. So the same principle came into play recently with the AATCLC and ASH case that was filed in California Federal District Court. So this case has to do with FDA's authority to regulate and prohibit the sale of menthol. As I'm sure all of you are aware, the Tobacco Control Act prohibited characterizing flavors in cigarettes, but it exempted menthol. But Congress in the Tobacco Control Act required TIPSAC to study the impacts of menthol on public health, and it issued a report in 2011, pretty much concluding that it would be beneficial to public health to remove menthol from the market. There were industry lawsuits that followed that report, but basically the conclusion has never, FDA has never wavered on that conclusion. It issued its own report in 2013, concluding the same thing. Public health groups, including AATCLC and the Public Health Law Center, filed a citizen petition asking FDA to remove menthol from the market, and that was in 2013. And then shortly after that, in 2013, and then again in 2018, FDA has issued advance notices of proposed rulemakings, which are basically notices to the public that FDA intends to consider moving forward with the rulemaking. Nothing has happened, obviously. So in June of this past year, public health groups came together and said, this is not right. FDA has delayed this process for too long now. It's been 11 years since it obtained authority over tobacco products, and it's been almost 10 years now since that first report was issued, and nothing has happened. And FDA had failed to respond to the petition that public health groups submitted in 2013. So now that's been almost 7 years, or it has been 7 years. So basically, these groups are saying this is not acceptable. The law that has been used by all of these groups to sue FDA is called the Administrative Procedure Act. And in a nutshell, that law enables litigants to require agencies to do things that the agencies are required to do by law, or do things that the agency has unreasonably delayed. And then it also enables litigants to challenge actions that are arbitrary and capricious, and or otherwise not in accordance with the law, which are the arbitrary and capricious language is probably something that you might have heard before, and that comes from the Administrative Procedure Act. So this tool exists to help public health groups hold FDA's feet to the fire and point out, Congress gave you these mandates and you haven't done anything. You have to respond to our petition. And you've already concluded in this situation that that menthol, the continued sale of menthol is causing death and disease. It is negative. It does not have any public health benefit. It is harming public health. It's causing excess deaths. And, this needs to come off the market. So these are, we're going to talk more about the ATCLC case in the webinar happening in a couple of weeks. So I encourage you to tune into that, and we'll delve a little bit more into it. But I just wanted to briefly explain why these cases are so important. And as Desmond mentioned, my background is in environmental law. So I wanted to talk a little bit about how environmental groups have used affirmative litigation as a tool to force EPA and other agencies that regulate environmental issues to take action. And there have been an inordinate number of cases. And so it was kind of hard to pick a few, but I've chosen 4 to focus on. Just because I think each of them sends an important message to public health folks about how important affirmative litigation can be in moving the public health and the environmental agendas forward. So the first one is a case called Sierra Club v. Morton. And basically, in brief, had to do with a lawsuit. Sierra Club sued the US Department of Interior over the development of a Disney ski resort that was planned for Sequoia National Park. This went all the way up to the US Supreme Court, and the US Supreme Court determined that Sierra Club was not able to adequately show that it was injured by Disney's plans to build a resort. The injury piece has to do with kind of some of the jurisdictional requirements that you have to show when you're bringing a lawsuit. But and you might be wondering, well, okay, they lost the case, why is that important? But the point is really that even though Sierra Club lost the case, this case was really, really important in establishing some of the requirements for showing that you've been injured, for showing that you're part of an organization and you've been injured. And it also ended up slowing the development of the project, which was not ultimately never completed. So, you know, it may seem like it was a loss, but it's important because it establishes that even if public interest focused groups sue and lose on some sort of technicality, they can still achieve the outcome that they were hoping to achieve. And they can also have really significant impact on what happens later down the road for other litigants. And this case has implications way beyond environmental law too for establishing those injury requirements that I talked about. And then the final thing I wanted to point out about this case is it was pretty early in the existence of some of the major federal environmental laws that we have. So using litigation as a tool has been an important strategy for environmental groups essentially since a lot of these, ever since the inception of a lot of these federal environmental laws. So the next case is Chevron v. NRDC. It's also a case that occurred in sort of the early stages of some of the Clean Air Act, for example. Basically, this had to do with the Natural Resources Defense Council's lawsuit over EPA's interpretation of one specific provision of the Clean Air Act. I'm not going to get too deep into what that was, but the idea was NRDC disagreed with EPA's interpretation, and it went up to the Supreme Court, and the Supreme Court determined that EPA's interpretation of the specific Clean Air Act provision was reasonable. And this was an incredibly important case. It's arguably the most important case in administrative law because it established a principle that's called Chevron deference, and it basically means that an agency gets deference but from a court when it's interpreting a law, its own law, or in issuing regulations. And what that basically means for folks on the ground is, depending on the administration that we're in, that can be really helpful. It can give the agency a little bit of leeway to go further than maybe other administrations would. But most recently, with the Trump administration, it's been an issue, and there's a lot of litigation from environmental groups over all of Trump's efforts to roll back Obama-era rulemakings and a whole bunch of other things. So basically, point is here, the role that public interest litigants can have in pushing forward administrative law decisions that have really far-reaching implications is significant, and the impact that that groups can have is very likely going to be much larger than potentially the one issue that one substantive piece of the litigation that is focused on. So then the next case is Massachusetts v. EPA. This is particularly relevant to tobacco control because it has to do with a petition. So several states and Massachusetts petitioned EPA to regulate greenhouse gases from new motor vehicles. As I mentioned before with the AATCLC case, one of their claims has to do with a petition as well. And these are similar, petitions to institute rulemakings to the agencies. EPA denied that petition, saying that the Clean Air Act did not authorize it to regulate greenhouse gases. And Massachusetts appealed the denial of that petition. And this went all the way up to the Supreme Court as well. And the Supreme Court ruled that on two different grounds. One was procedural and one was more substantive. But first, it ruled that Massachusetts had what is called standing to sue EPA. So that was that injury requirement that I referred to before. So it found it had standing to sue EPA over the potential damage from global warming, which could include sea level rise and all the other problems that Massachusetts is going to face. And it concluded from a substantive standpoint that EPA has to regulate greenhouse gases. And this was a really important procedural and substantive win. It's arguably one of the most important cases in environmental law. And it started with a petition. It started with a citizen petition. In this case, it was states. But just like the menthol petition, the Administrative Procedure Act gives environmental groups, it gives public health groups, it gives states the authority to petition agencies to institute rulemakings. And so in the menthol context, FDA wasn't acting. And so public health groups got together and told it needed to institute a rulemaking. And that, while it's not specifically filing a lawsuit, it often will lead to litigation because the remedy is filing an appeal in court. So the point here is really to highlight the role that petitioning agencies to do things can play, and then the follow-up litigation can be incredibly instrumental in making huge policy change and wins for public health. And then the last case that I wanted to focus on is the Standing Rock Sioux Tribe v. the U.S. Army Corps case. So I'm sure many of you are familiar with this issue. This is the Dakota Access Pipeline that the U.S. Army Corps permitted to cross underneath Lake Oahe, which is upriver of Standing Rock Sioux Nation. And it did not consult with the tribes. It did not adequately consider the environmental impacts, the potential impacts of spill to water. And the district court agreed with the tribes here. It's in a series of rulings over the past year or so found that the consultation process was insufficient, the environmental review was insufficient, and then recently the district court found that the pipeline needed to be shut down pending proper environmental review, because technically the pipeline never should have been built before adequate environmental review was done. This is a really timely case to talk about too, because there was actually a hearing yesterday before an appeals court panel on whether or not the pipeline needs to be shut down. And it's ongoing, but it really shows how significant litigation can be, but also that it's not a tool in and of itself. As Desmond talked about before, it shouldn't replace direct action. It shouldn't replace organizing. And this story really has highlighted how important all of these tools are to fit together. And it also establishes that the environmental movement and the environmental groups that have been bringing lawsuits are not just like the big green groups. It's folks who are really concerned about environmental justice, which is in and of itself a component of public health. And especially when we're talking about things like climate change, they're one and the same. And also litigation has been an important tool for the environmental movement, the environmental justice movement since its inception. And it will continue to be a really important tool, especially in the climate change context. So I could go on about a lot of other cases, but these were the ones that I wanted to highlight to just show how important some of this work has been in moving both public health and environmental interests forward. So with that, I am going to attempt to share a new resource that we have. And Hopefully, okay. So we realize that there's a lot of litigation going on. It's litigation against FDA by the industry. It's public health interest litigation. Um, all different types of cases are creating really important policy change and moving public health in all different directions. And we think it's really important to keep track of that litigation and provide what we hope are easily accessible descriptions of what the most important pieces of those cases are, and then also bring together some of the documents that are useful, the complaints, some of the rulings. And so we are putting together a litigation tracking database. And this is really similar to the amicus brief database that we had, only it's broader and it's going to encompass cases that are not just ones that we filed amicus briefs in, they're just all of the significant public health cases. And they're also going to go beyond commercial tobacco. So I just wanted to provide a little bit of an introduction to what this is going to look like. This is our website. You can find this under the About Us tab on our website. It's just litigation tracker. And you'll see that there are options to search cases by keyword. We have different public health topics, different legal issues. You can search by state, and then whether or not the case is ongoing or closed, but you don't need to select any of this. You can also just go down and, for example, this is one of the cases that we talked about, the Massachusetts American Academy of Pediatrics case, basically a synopsis, background, and description of what happened in the case. And then this is a new resource for us, and we are in the process of building it out, adding documents, and we also really want feedback on this. So if you go to our website, take a look at it, and you are seeing something, not seeing something that you would like to be there, or you have feedback on how it should be structured and what types of documents we should provide, we would really welcome that feedback. And we'll also be rolling this out over the next couple of months, so stay tuned. And let's see. With that, I'm going to stop sharing my screen. And Desmond and I are going to ask each other a couple of questions and have a little bit more of a discussion about some of the things that we've discussed. And then we will open up the conversation to questions from you all. So please, as Stephanie said, please put your questions in the Q&A. It looks like maybe there are some in the chat, but and let's see.
Yeah, feel free to start throwing those questions in there. Like I said at the beginning, this is going to be sort of informal. We thought it might be a little better, a little reprieve from just PowerPoint slides. So let me ask you something, Kira. Maybe this isn't a great question, but I'm gonna try to phrase it the best that I can. So I'm always like intimidated by environmental litigation. Like there's just, the volume of it is just incredible. There are so many like NRDC v EPA. I'll have Roman numerals after them, so many. And I couldn't possibly keep track of all of them. But obviously, I mean, the Clean Air Act and the Clean Water Act are Nixon era statutes. The EPA has been around for a long time. We haven't had a federal regulatory scheme for tobacco control for very long at all. I mean, comparatively, right? So, but we also really haven't had, I mean, there are 3 cases against the FDA from public health. There are at least, well, with the deeming regulation cases sort of aside, because there's, you know, like a dozen, but other than that, there's been, you know, a handful by industry. It feels like the comparative volume is lower. And I mean, I think definitely from public interest to where public interest plaintiff, government defendant too. Does it seem like the reason this is not a great question maybe is because I'm asking you to like
think as a historian, not necessarily as a lawyer, but do you think that like 10 years removed from some of those big environmental laws, that there were significantly more lawsuits against government from public interest versus where we are now? I mean, I obviously this is apples and oranges, but it feels like a low volume to me, but I also don't really have a benchmark. So
I think there were many more cases being filed, not only against EPA, but as I mentioned, one of the cases was against the Department of the Interior. Um, so I think there were unquestionably more cases being filed sort of in the first 10 years after some of those major environmental statutes were passed. But I think that there's at least a big reason for that is not only the number of agencies that regulate, but the number of issues that EPA is in charge of. The fact that some of those cases are going to be state permitting decisions, so the state implementation of those laws, it might be, you know, a lawsuit over the permitting of a specific plant. And also the National Environmental Policy Act, NEPA, is a statute that every federal agency is required to comply with, including FDA. And so when environmental reviews are done, I mean, there's just so many more, you know, opportunities to interject. And so I think that it has a lot to do with all those different factors. But yeah, good question.
yeah, no, I mean, I think that makes sense. It also sort of occurs to me while you were saying that I think, well, I mean, tobacco control is a very niche part of, you know, public health more generally. And so like litigation against just the Center for Tobacco Products is, I mean, it would make sense that you have a smaller volume, right? The other thing, I think there's definitely parallels though in like the amount of technical knowledge. I mean, groups like the Sierra Club and the NRDC, they have like an incredible depth of knowledge of specialists, of scientists. And I think we absolutely have that same thing in tobacco control. I think we sort of think of ourselves as like the little guys. And I mean, I don't think any of the groups that work in tobacco control are nearly the size of some of the big environmental groups. You know, maybe with the exception of some of the large health voluntaries. But I mean, we have that same sort of level of expertise that could be set to play in litigation. I mean, we do a great job in the context of advocacy before the legislative branch and the FDA, and sometimes it's the same sorts of issues that play out in litigation too. And that actually leads to one of the other things that I think we could maybe talk more about for a minute too. It occurred to me when you and I were talking about this when we were setting things up that a lot of the litigation, a lot of the lawsuits that we're talking about on the tobacco side and on the environmental side, there are like really important substantive issues that play. Like the three public health cases against the FDA are about graphic warnings, pre-market review, and menthol on cigarettes. And I mean, those are huge and have tremendous public health implications. But all three of them, the actual legal issue is super procedural, and sometimes like kind of to a degree that I don't know that people really fully grasp. And so, you know, litigation can be a really interesting tool in that respect, in that it's not just about here's all the science that tells you should act on menthol. The menthol case is also about the fact that the FDA hasn't acted on a citizen petition that was filed, and there's a statute or a regulation on the books that says here's your deadline, and it's not been met. And you know, that's sort of the same issue in the graphic warning case. And the pre-market review case is about what degree of enforcement discretion means you're just not doing what you're supposed to do. And I mean, you've spelled it out pretty clearly in the environmental context too, but it's just, I think in the administrative law context in particular, I think that can be another sort of barrier to people who are thinking about using litigation as a tool. I don't know that the organizations that were litigating those issues, you sort of have to find the right hook, right? And I think in the environmental context for sure, I think some of those cases, the groups found like really brilliant legal theories to pursue. Actually, maybe you want to expand a little bit on the Sierra Club v. Morton, because I feel like that's one where you have the sort of lesson is that or at least one of the lessons is that a win doesn't necessarily look like what you think it will. It's a little bit about how litigation can sort of be outside of your control, right? The lawsuit was brought for one purpose, but the end result, a really important ruling, but totally not what would have been expected.
Yeah. As you're talking, I mean, I think one significant thing to keep in mind is, so Sierra Club v. Morton, for example, it's a challenge to a specific development project. And I think that there are so many more places for environmental groups to get involved in situations like that. And the goal might be to figure out any way possible to reach the outcome, which might be delaying the development of the project, which was ultimately accomplished. And in the context of commercial tobacco control, I just don't know that we have those same like pressure points that are available. But that isn't to say that with some creative thinking, those points aren't there. I mean, we talked a little bit about how some of the local governments that are passing, really broad flavor restrictions are doing so with the knowledge that they're likely going to get sued, and doing that and moving forward with those policies regardless. And even though in those cases it's the industry that is pushing back and suing the local governments are really kind of like taking the lead there, and they are kind of engaging in their own kind of proactive, I mean, it's not affirmative litigation, but it's still they're involved in litigation in a way that is protective of public health. I don't know if that really speaks to what you're talking about, but it's just like another a more localized way that litigation is significant in making major changes. And actually, you might want to speak a little bit to the Rhode Island, the value that like precedent can play in pushing policy forward too.
Yeah, that's a good point that we sort of alluded to. I mean, you have cases like Chevron. I mean, every lawyer that goes to law school hears plenty about Chevron. It's just like this landmark case. The precedence is so sweeping and important, but you don't always have to have that level of applicability to other litigation to have like a super important ruling that covers a lot. And I think, yeah, the Providence case is a great example. So the first two jurisdictions to really tackle flavors and tobacco products in a way that is at least somewhat comprehensive was New York City and Providence. And both of them got sued very early on, and both of them won their lawsuits at the lower court level and on appeal. And those were in federal court. And so they set precedents for the whole circuit that's covered by the Court of Appeals. And Providence is in the First Circuit, which is Rhode Island, but it's also most of New England. The circuits are drawn on a map in ways that aren't always totally logical, but the First Circuit at least is tight and small, and it's New England. But after you have a decision from the First Circuit, like they did in Providence, that held that as a matter of law, these sorts of flavor policies are not preempted by the Tobacco Control Act, almost every community in Massachusetts started passing laws that were virtually identical, if not identical, to the language in Providence. And that means that if a manufacturer or retailer went to sue one of those cities, it'd be thrown out of court immediately because of the result in Providence. And so you can have one city sort of take the bold step and really prepare for litigation in a way that Providence did, and really think through everything and have a good result. And then that creates a shield for other communities, and we can sort of take these incremental steps forward in regulation. One of the questions that came in is about the fact that because litigation can often take a long time, it can be challenging to use it to sort of deal with more of the quicker moving short-term issues. And the example here is the AAP case in Maryland related to pre-market review. And I think that's a really good point, that in that case, the FDA had sort of kicked deadlines down the road really far, and then public health groups challenged that. But by the time the ruling came down, you had time elapsed during the litigation. You sort of have ongoing damage happening. And I think luckily that case played out fairly quickly. But I think maybe we should talk about some of the, there are plenty of attempts, particularly when industry sues governments, to try to hold policy, to get temporary injunctions and preliminary injunctions to stop a policy from being implemented while the litigation happens. And that's a tactic that sometimes works and sometimes doesn't. But when it is successful, even if a policy is ultimately upheld, the industry sort of gets a temporary win. I don't know if there are sort of lessons learned or anything similar in the environmental context, but it definitely comes up in tobacco control, usually for ill, not for good. But
yeah, that question is a really good one. I like the idea that it might seem kind of counterintuitive, that you'd file a lawsuit that's going to potentially take years and years to get an agency to act more quickly. I think some of the relative speed in that case, I think just had to do with the questions at issue and the fact that it was really, it was resolved on a what's called, I'm pretty sure it was a summary judgment motion, but it didn't require some of the more lengthy things that make litigation a lot lengthier. So discovery and all of that process. I don't think there was really a way to drag that out in the same way that some other cases can be dragged out, and that's one benefit of a lot of litigation against agencies, is that you normally don't have that very long discovery process or paper flinging back and forth. You might, and obviously in some of the historic cases, discovery was really important. But I mean, I think one crazy thing in that context and in some of the FDA action is that they delayed things so significantly that even a year of litigation resulted in a much speedier process than would have happened had there not been any litigation at all. And when the agency is just not doing anything, I don't know what the other this is such an important way to force it to do something. I mean, you can ask for as many meetings as you want with the agency, but if it doesn't do what it needs to do, then you're kind of stuck with this one maybe kind of blunt tool. but yeah, I think something to keep in mind is definitely that this is not a process that will result in speedy outcomes.
For sure. I think also, I don't want to like hit this as something that's super important necessarily, but I think that in that case, I mean, I think the litigants, the public health groups did an excellent job in pleading their case and doing what needed to be done. And they also, I think, got incredibly lucky in getting a judge who could grasp a really complex regulatory issue and understand how important the the public health impacts of that behind it. And that's not necessarily always the case. And I think that can be one of those things that sort of can make litigation feel really arbitrary. I mean, the sort of opposite result is, I think, what happened with the first FDA graphic warning rule, where the judge hearing that case at the lower court level was, a very honest, upfront libertarian judge who just didn't believe in government regulation of most things. And that was a First Amendment challenge, and the First Amendment test applied to the government's warning labels was the same one that we would use if a government tried to stop people from, protesting or from, it was the most stringent First Amendment test that can be applied, and it was patently wrong, and that was corrected on appeal, even though the case was still struck down. But the judge that you get in front of can have an impact on how things go. And actually, I think that there's another lesson there too, in that in the federal courts in particular, some circuits are more friendly to certain things than others. And correct me if I'm wrong here, but I think you find a lot of environmental cases filed in the Ninth Circuit, which tends to be, more liberal per se, or at least more understanding of the importance of environmental regulation. Maybe that's a better way to put it. And so when you are an affirmative litigant rather than a defendant, you get to pick which court you file in. And when you sue the federal government, you can sue them in any district court in the country, so long as you have a reason to be in that district court. But you can sue the government wherever you are. And so if you file, you'll see, let's be brutally honest, you'll see the current challenges that industry are bringing against the FDA. They're filed in places like the Eastern District of Texas and the Southern District of Mississippi, the Western District of Kentucky, and that's not a coincidence. Whereas the public health cases are filed in places like the District of Columbia or the Northern District of California, which is in the Ninth Circuit. And so the place you go dictates what judge you get in front of, and that sometimes that can have a huge impact on how things go. I don't know if you have anything else to say about that before we wrap up.
I think that's a really important point. You're 100% right about that. And yeah, I mean, it swings back and forth too, because with the Ninth Circuit, we've seen a bunch of new appointments that are not going to be as friendly to some of these issues. And I mean, obviously on the Supreme Court, well, it's going to change a lot of the way that some of the Chevron doctrine too might lose some of it. It might be whittled down. We'll see what happens. But anyway, yeah, we're out of time. So thank you all for joining us. And if you have any last words of wisdom, Desmond.
Yeah, no, thank you everyone. This was really fun. I like just talking litigation. Again, we've got a couple more webinars coming up, also focus on litigation. Hopefully this is useful and demystifying to a degree. When you get out of the webinar, there's going to be a survey that'll go out. We really do encourage people to fill those out. We actually read all the results, and they help us plan for the future and create tools that are useful for you. So thanks again, and hopefully we'll see you again soon.
Thanks.